We've had a very good morning in the Sydney Opera House in Sydney. It's a bit of a strange day, very windy outside, but lovely views of the Sydney Harbour. We have a few of us in the room with us, but otherwise most of us are online. Well, we're all online, but most of us are going to be joining from our respective locations. So welcome to session 3A. We're looking at drafting international arbitration agreements, and this session is intended to be more focused on lawyers rather than the commercial or business groups. The session 3B is focusing on the commercial teams. So the approach that we're going to look at today is to very much look at different types of arbitration, institutional arbitration and ad hoc arbitration, and to look at some of the options or elements to include in an arbitration agreement, and then to give you some tips and traps. So I have a very esteemed panel with me who are joining from all over Asia, which is wonderful. And I'll introduce them first. I'll start with Ko Sui Yen, who is joining us from Singapore. Ko Sui Yen is a partner in the disputes and arbitration team at Wong Partnership. She's involved in a wide range of complex, high-value cross-border disputes that are resolved through the courts and in arbitration using all of the major arbitration rules. And she's been involved in a number of arbitration bodies, including the IBA Arbitration Committee. We have Mei Tai from Hong Kong, who is the Asia Managing Partner of Herbert Smith Freehills. Mei focuses on cross-border China-related and Asian disputes, as well as contentious regulatory matters. She's also heavily involved in many institutions, including HKIAC in Hong Kong. We have Daniel Calderimus in New Zealand, who is a leading international lawyer with over 20 years experience, and also in complex cross-border disputes. So Daniel was formerly head of the international law team at Chapman Tripp. I think there's someone who needs to go on mute. And has recently just joined chambers at 20 Essex Chambers in London, and is also in chambers in New Zealand with Thorndon and Richmond chambers. And then we have, last but not least, Abhinav Bhushan, who is Regional Director of the ICC Arbitration and ADR Office looking after South Asia. He's based in Singapore. Abhinav has more than 10 years experience with the ICC, acting as the ICC's first Indian director and the first Indian deputy counsel of the court. So Abhinav will give us some interesting tips on ICC arbitrations. So I'm just going to share my screen with the slides. Bear with me a moment. Right. And we'll start with our agenda. As I mentioned, we're going to be focusing on arbitration, but we'll just briefly look at some of the other options for dispute resolution and the benefits of arbitration. Then we'll look at ad hoc versus institutional arbitration, look at some of the key elements for drafting an arbitration clause, some of the optional provisions you can include, and then we'll look at tips and traps for drafting arbitration agreements. So just very briefly, there are obviously other forms of dispute resolution, and negotiation is the first step that our clients will, or commercial parties will start with. Increasingly, mediation is the second step, and in Australia in particular, it's almost as if no dispute will go forward without a mediation, if not in the early stages of the dispute resolution process, at some stage during the dispute resolution process. But then you have three forms of third-party decision makers, forms with third-party decision makers. So you have expert determination, litigation in the courts, and then you have arbitration. And I just wanted to emphasize a couple of the key benefits of arbitration before we start looking at drafting clauses, and link these a little bit in with the comments made by Gary Vaughan this morning and his now 6 E's. I'm not sure I can get in 6, but I'll try my best. So firstly, one of the benefits of arbitration over litigation at least is that you get to choose an independent tribunal. So that goes with the even-handedness that he mentioned. The tribunal is independent. They will apply a fair process and ensure that procedural fairness is upheld. And they also satisfy the expert requirement because you can choose a tribunal that is expert for your particular dispute. Similarly, in expert determinations, you can also choose an expert that's appropriate for your dispute, but often expert determinations are really only suitable for very limited questions and often a very technical question where the expert can easily decide it within a very quick process. But in practice, there is not a lot of difference between expert determination and expedited arbitration. So there is still a benefit there to some degree about arbitration. Arbitration is a neutral forum and it has flexible procedures. So the venue can be neutral to where the parties are, which is very important in cross-border disputes. The use of procedures that are suitable to the particular type of dispute is incredibly important. And this is where the efficiency and expeditiousness may come in that Gary mentioned this morning. It's a binding outcome with a limited right of challenge, usually no appeal on the facts, and usually no appeal on the law. So that can be important for commercial parties who want to make a decision and move on. And then essentially it's confidential and private. Most of the arbitration rules now provide for confidentiality. This means even the existence of the dispute or the existence of the arbitration is confidential, and any working papers, the process, anything that's produced during the arbitration is also confidential, and the hearings are held in private. So this is obviously fortuitous for many commercial parties. But the key advantage really is enforcement, which is yet another E that Gary didn't mention, or at least didn't go into too much detail. And on this note, I'll hand over to my first panelist, Daniel, to talk a bit more about the New York Convention and the legal framework for arbitration.
Thank you, Joe, and hello, good afternoon, good morning to everyone. So what I'm going to do is just briefly map out the architecture that applies when you're determining how your arbitration is going to be set up. And I know that a lot of the people listening will know this, but it's helpful just to rehearse how the bits and pieces fit together so that when you come to the nitty-gritty of drafting the arbitration clause, you're not only focusing on the detail of what goes into that clause, but you've got a good grounding in how that detail fits in to that wider architecture. So this slide shows, if you could count all of the flags, and assuming it's perfectly up to date, the 167 parties to the New York Convention, which is a convention that was signed back in 1958 and is one of the most far-sighted pieces of private international law, in that its drafters foresaw that something like international arbitration was a really good way to resolve cross-border disputes, but would only work if it had a solid treaty base backing it. And the effect of that treaty base is that if you put an arbitration clause into your contract, which is of course what we're talking about here, there are two consequences that apply with respect to the member states that sign up to the New York Convention, those 167 convention countries. The first one is that those member states will agree that you will be made to honor your arbitration agreement. So if you try and litigate, or the other party tries to litigate in breach of the arbitration agreement, they'll be forced into arbitration. No ifs, no buts, no maybes, no proportionality test, just what you've agreed to, which is your disputes determined by arbitration. And that is different than what you get even if you sign up to an exclusive jurisdiction clause, providing for national court litigation, where the same general result prevails, but there are more ifs and buts and maybes as to whether you'll actually have to honor that agreement in the end. The second consequence is that once you have an arbitration award, it is easy to enforce using a simple registration process, again, with not no ifs, buts, or maybes, but few and defined reasons for refusing to enforce an arbitral award, and none of them based on the merits of the award, all of them based on important manifest procedural problems that if they have affected that arbitration may be a reason for not enforcing it either in the jurisdiction where the arbitration was held, which we call the seat, or in another jurisdiction, perhaps where the assets of the debtor party are located. So that's the treaty base, and most everywhere that you either arbitrate or you look to enforce is going to be a New York Convention country. The basic tip here is don't put the seat of your arbitration in a non-New York Convention country, but that's getting increasingly more difficult to do. So that's the first part of the architecture. The next part of the architecture on the following slide is the idea that the New York Convention isn't where everything begins and ends, because the New York Convention isn't a statute, so it doesn't govern the rights and obligations that exist within a country. You actually need to look at the arbitration law of that country. And before you immediately just go and pick up the arbitration law of that country, there's oftentimes, not always, but oftentimes a middle step, which is what's in the middle of those three half circles, being the UNCITRAL, United Nations Model Law on International Commercial Arbitration, that comes from the mid-1980s and was then updated again about a decade ago. So the model law is the second major instrument here. Unlike the New York Convention, it's not a treaty, it's a model national statute. But having said that, very many countries do model their arbitration laws on that statute. And so it pays, when you're trying to understand what a national arbitration act provides or doesn't provide, to sort of split your screen in two and to look, on the one hand, what it says, and on the other hand, what the model law says, because whether your national statute agrees or diverges in part from the model law will have been a part of the thinking that went into how that arbitration statute is drafted. And the model law is designed to work hand in glove with the New York Convention. So Articles 35 and 36 of the model law, which are the recognition and enforcement provisions of that model statute, are designed to operationalize the New York Convention vision that it should be very straightforward to enforce an arbitral award that was rendered in a New York Convention country. And so then if you look at that diagram, you can see, for instance, the Fiji Arbitration Act, but you could say the same thing for Singapore or Hong Kong or Australia or New Zealand, have all worked those provisions into their national legislation, and so they're model law compliant countries that use a model law sort of process for enforcing your arbitration award. So that's the second step of the architecture. And if we go to the third step, which is on the next slide, what that provides is that when you come now to draft your arbitration clause, what you know is that the clause is going to be construed and will fall to be applied within that rectangle of the law. So you have to read that law carefully, because you have to know that you're not putting something in your clause that you're not allowed to put it under that law. And if I give you an example, some parties to a New Zealand arbitration about a decade ago decided to put in a special mode of recourse against an arbitral award in New Zealand. They thought it would be a good idea to allow an appeal on a question of fact against a New Zealand arbitral award. Turns out that under the New Zealand arbitration law, you can't have that. It's not provided for. And the fact that the parties picked a mode of recourse that was not permitted meant the whole arbitration agreement was invalid. So you want your clause to fit comfortably within the rectangle of the law, and in order to know that that's going to be the case, you have to read the law carefully, and then you'll understand that in many cases the law will itself be based on the model law, and the model law is designed to fit with the New York Convention. And then the final piece of architecture is that even though we've gone very quickly through these different instruments, the New York Convention Treaty, the model law, the national arbitration laws, none of them really tell you what the detail of your arbitration procedure has to look like. That's a choice that you effectively get to make. That's because the philosophy of all of these instruments is usually to preserve the autonomy of the parties and the inherent flexibility of the arbitration process, which is by and large a good thing, but it also means that you can get to the beginning of your dispute with suddenly a rather big black hole where if you are litigating a whole lot of detailed rules from how you make a security for costs application to what a witness statement has to look like would ordinarily fit. And the usual fix for that is to incorporate by reference through your arbitration clause one of a number of sets of available international arbitration rules, which give you the advantage of covering up some of the procedural ambiguity that might otherwise arise, and to give you some assistance in going through the arbitration process. And if you look at the clause that follows, this compares two types of arbitration processes, what we call institutional arbitration, which is where you have incorporated a set of rules that includes a secretariat to help you along, and ad hoc arbitration, which is where you either haven't incorporated a set of rules at all, or you've incorporated a special set of rules that doesn't include any institutional support. And the main proponent of those rules is the UNTITLed arbitration rules, now in their 2010 iteration, which are designed to fit with the UNTITLed model law, but don't come with a secretariat or any institutional supervision to help you along. So that's a very brief overview, and Joe may wish to expand on some of those concepts.
Thanks, Daniel. Well, I'll invite Abhinav actually to look a little bit more into the advantages and disadvantages of ad hoc versus institutional arbitration, particularly some of the benefits of institutional arbitration. And then if you could also talk a little bit about the ICC arbitration.
Thanks, Joe. As Daniel mentioned, what makes an arbitration ad hoc, what makes an arbitration institutional, is actually what you put in the contract. So if you put in your contract your dispute resolution clause where you don't choose a particular set of rules, in particular, if you don't choose a particular institutional set of rules, then your arbitration is likely to be ad hoc. However, if you, and it's a matter of great importance as to how you draft your arbitration clause, if you put in an institutional clause, then you will have an institution administer your arbitration. And I'll tell you what that really means. There are many institutions one can choose from. And I think the next slide will give you an idea of what institutions are available in the region. So key arbitral institutions, as you can see in the region, are the ICC, SIAC in Singapore, the Hong Kong International Arbitration Center in Hong Kong, AKICA in Australia, and two that you can see on the screen in New Zealand. Now, the fundamental difference between an ad hoc arbitration and an institutional arbitration is that in an ad hoc arbitration, you're pretty much left on your own. The parties and the tribunal follows a set of rules. It's likely normally the national legislation, the Australian Arbitration Act or the Singapore Arbitration Act, which in most cases is based or partially based on the UNTITLed model law, and the parties follow the procedure mentioned herein. However, in an institutional arbitration, and I can say this with much confidence, that the world that we live in today is moving towards institutional arbitration. And the reason for that is that the institution provides the much needed framework, the much needed supervision in the context of an international arbitration. So typically what you would do is that if you have an institutional arbitration, for instance, the ICC, you will file your request of arbitration with the ICC. The ICC will then notify that request to the other side, to the respondent or respondents as the case may be. The ICC will assist, the institution will assist in the constitution of the tribunal. The institution will then transfer the documents to the tribunal. The tribunal will then draft the procedural timetable and the terms of reference, which is a typical ICC document, and then invite the parties for their submissions, have the hearings, and then draft the award. But the advantage that parties get by having an institution is that the institution supervises this entire process. I can tell you from experience that an arbitration, there are arbitrations and there are arbitrations, but when things go really Oreo, or things go really complicated, it is the institutional support that comes a long way in moving your arbitration forward. For instance, if you do not have a respondent that is participating, most institutional rules have a default mechanism in appointing an arbitrator. The idea is that your dispute should be resolved in time, and your dispute should be resolved by you not knocking the doors of a national court every time something goes procedurally wrong in your arbitration, as what happens in many cases. The Secretariat essentially will look after in ensuring rather that the timelines, the procedural timetable is followed up to the extent possible. The institution will follow up with the arbitrators in case they have a procedural difficulty in understanding an aspect of how to interpret a particular institutional rule. The institution, and this is where institution comes most handy. Look, the entire process of arbitration, why parties resort to arbitration, is that at the end of the day, because of the New York Convention, you can enforce an international arbitration award, and I believe in now more than 170 countries, with 2 countries ratifying it as early as last week. You can actually take that award and you can enforce that award in over 168, 170 countries. But what do you want from that award? The example that I like to give is that award should typically work like an ATM card, that you insert your card in an ATM machine and the ATM machine gives you your dues. Likewise, you take that international award to a national court and the national court should enforce that award and give you your dues. But what factor will help a national court do that? In order for a national court to do that, that award should be clear, concise, well-reasoned, and without errors. And that is where the institution really comes in handy, because the institution scrutinizes the award before it goes out to the parties. This would never happen in an ad hoc arbitration. And I can tell you, with the last 10 years that I have spent at the ICC, we are all great lawyers, but when it comes to certain things like numbers and character errors, we make really terrible mistakes. And you make one mistake in an award, and then you are set back by another 4 or 5 months, or even more as the case may be. The scrutiny strengthens the award. The scrutiny makes sure about all the things that Daniel recently spoke about Article 5 of the New York Convention. If procedurally anything goes wrong in an arbitration, then it is likely to be set aside or not enforced in the context of a country, especially in a developing or a developed jurisdiction. Then how the ICC also supports arbitration is by monitoring the financial aspect. In an ad hoc arbitration, you're pretty ad hoc. The arbitrators will tell you how much money they need and their hourly rates, etc. There is no real structure to the cost processes in an ad hoc arbitration. But in an institutional arbitration, be that SIAC, ICC, or the others, the institution constantly, on a daily basis for that matter, monitors the cost. If the tribunal is not doing the job properly, ICC goes as far as actually reducing the fees of arbitrators if they do not do the job in time or if they're delayed in their arbitrations. The institution, actually, we are the only institution, and we've done this, that if there is a delay from the institution's side, if the ICC makes a delay in appointment or appoints an arbitrator who doesn't do the job properly, then the ICC actually reduces its own administrative expenses, because that's the responsibility that an institution should take towards its clients or users who put that institution's clause while drafting the contract. Last and certainly not the least, there are so many other sort of add-ons, accoutrements of sorts to an ICC or an institutional setup. You can have the ICC act as an appointing authority, or you can have an institution like the ICC act as an escrow agent to deposit your monies. The institution will make sure that it gives you copies, certified copies, as many as you like. And I mean, this one conference or this one little session is unfortunately not enough to highlight all advantages of an institutional arbitration. But suffice to say that tomorrow, if you have an option to add on an arbitration clause in your agreement, then I would highly recommend that you put in an institutional arbitration and not an ad hoc arbitration. And I think I'll give it back to Joe to highlight perhaps other institutions and their advantages. or the suite?
Thanks, Abhinav. I think I'm going to borrow that ATM analogy in one of my future descriptions of the New York Convention and the benefits of enforcing an award under the New York Convention as opposed to a court judgment. And I think I just also want to emphasize the importance of scrutiny of awards that the ICC does, and having been involved with that for a couple of years, the amount of effort that's involved to make sure an award is enforceable is really commendable and definitely an advantage of the ICC. Since we have so many representatives from across the region, we thought that it was worthwhile just briefly each of us describing one benefit or one key development within each of these institutions before we move on to actually drafting an arbitration agreement. So first, if I invite you, Sui-Yen, to talk about SIAC in Singapore. And then if you could jump in, Mayte.
Yeah, thank you very much, Joe. And thanks, Abhinav, for that introduction as to the various benefits of an institutional arbitration over an ad hoc arbitration. I guess the question then becomes, which institution? Because if we look across all the institutions, they all have very favorable rules, which do help to expedite and ensure that the arbitration is proceeded in a cost-efficient way. What I would just like to highlight are perhaps some interesting features of the SIAC rules, which may not be found in all the institutional rules. I know Joe mentioned that I should do so like 1 or 2 points, but I would like to do 2 points quickly. Number one, the SIAC rules actually have an early dismissal process under Rule 29. What makes it unique is that this early dismissal process actually applies to the early dismissal of a claim or defense. So in a situation where you have a manifestly without legal merit claim or defense, you could actually get an early judgment. And I think this speaks a lot for the efficiency of the proceedings. Number two, while all the institutional rules also have the expedited procedure, where the award can be given in under 6 months from the time of constitution of the tribunal or even shorter, what is interesting about the SIAC rules is that the monetary limit is about US 4.5 million. So anything below that can be put to the expedited procedure. And I think the ICC threshold is about $3 million US, and HKIAC is also around that region. Thank you, Joe.
And May, can you tell us about Hong Kong?
Sure. Taking over from Sui-Yen, I guess when people think about arbitrating in Hong Kong, the sort of common issue that pops up is whether there are any advantages to using Hong Kong as a seat of arbitration if you are dealing with a China-related contract where you have a counterparty who's a Chinese party, or a project or investment in China. And there is one important point, and happily it applies, the advantage of arbitrating in Hong Kong applies across the board to all the major recognized arbitration institutions, not just to HKIAC. And the advantage is this: basically, there are quite rigid rules about when you can approach the mainland courts for assistance in relation to interim relief, which is something I'm going to come and back to cover later on. And helpfully for Hong Kong, you can seek the mainland court's assistance if you have a Hong Kong seated institutional arbitration. And that is sort of an advantage that's just extended to Hong Kong as a second jurisdiction, and not something that is available if you are arbitrating, for example, in London, New York, Paris, and even Singapore to date. So that is something to bear in mind if you've got a China-related contract.
And Daniel, for New Zealand?
So the last two institutions on that slide are both New Zealand institutions. I wouldn't presume to suggest that either of them are of the significance or fame of the other institutions on that list, but 1 point on each of them. The middle one, the Arbitrators and Mediators Institution of New Zealand, or AMINS as it's called, is currently redrafting its rules to try and have a more nimble post-COVID world, simple set of rules that are going to be particularly appropriate for mid-low value disputes. So that is under advisement, and they're being redrafted at the moment. And the New Zealand International Arbitration Centre has a number of different expedited rules, largely for construction-related arbitrations, but they can be adapted for anything. So if you've got something that you think should be wrapped up in 120 days or less, you've got various different options to choose from.
Thank you. And finally, in Australia, we've got AKICA. The AKICA rules are also being revised at the moment, and I understand it will be announced shortly. There are a few developments in those rules relating, for example, to consolidation of disputes and multi-party and multi-contract disputes. So it'll be interesting to watch this space. I should also mention it might be of interest that AKICA recently issued a report on international arbitration in Australia, which looks at the volume of arbitration, the different industry groups, the different areas in which disputes are arising. So I think that's an interesting reflection for what is going on in the region as well, and might be relevant to what's going to develop in the South Pacific. So now we're going to move to actually drafting an arbitration agreement. And the first part to look at is the key elements of an arbitration agreement. And if I can invite Sui-Yen to talk a little bit about these.
Thank you, Jo. As you can see from the slide, there are various key elements in an arbitration agreement. And if we just start off with the slide and the circle that is right on top of arbitration agreement in the center, you will see that there's various 6 of them: submission to arbitration, number 2, the seat on the right-hand side, number 3, the arbitral rules, number 4, the number of arbitrators, number 5, language, and number 6, governing law, which I will end with. First and foremost, what do we mean when we say that you must find the submission to arbitration in an arbitration agreement? This, in essence, means that it would be good practice to make the reference to arbitration mandatory. How do you make a reference to arbitration mandatory? You would be using phrases such as shall be referred to and finally resolved by arbitration, as compared to a situation where you give parties the right to elect whether to go to court or to go to arbitration, or where you have both the presence of a court exclusive jurisdiction clause as well as an arbitration clause found in the same dispute resolution. That would create a lot of issues, which we'll come to at the later part of this session. That's the first point. Second, the seat of the arbitration. The seat of the arbitration is critical, absolutely important, because it provides the nationality of the arbitral award that you eventually obtain. The seat of the arbitration is also the law that governs the conduct of the arbitration. What does this mean effectively? If the seat of the arbitration is the nationality of the award, that is the jurisdiction and that is the place where, if you are dissatisfied with the award, you apply to seek to set aside the award on and from in the jurisdiction where the seat is. And in setting aside the award, you would be looking at what is the law of the seat of the arbitration as to what are the applicable grounds for setting aside an award. So for instance, in Singapore, because it's a model law jurisdiction, it will be on the model law grounds, and there are also 2 additional grounds provided in the arbitration legislation, that where it's contrary to the public policy and where there's a breach of natural justice. What about the point of it being the laws or it being the law that governs the conduct of the arbitration? That is very important too, because insofar as you require any supervisory assistance from the courts, then you would be looking at the laws of the seat of the arbitration. You would also be looking at the laws of the seat of the arbitration to see whether there's any mandatory provisions of law that may apply. And one other point that I should emphasize is that in determining the seat of the arbitration, it is always very important to go and look at the international arbitration legislation that applies in the seat. Because depending on the seat, it may allow you to challenge both positive and negative jurisdictional rulings. So for instance, Article 16.3 of the model law only stipulates that a challenge can be made to a positive jurisdictional ruling, but it doesn't state so for negative jurisdictional ruling. But if your arbitration is seated in Singapore, the Singapore arbitration legislation actually allows challenges for both, which I understand is not necessarily the case for many other jurisdictions. So deciding the seat is critical. And I should also add at this point, the seat really refers to the country, and please refrain from using the city, because the country is the entity and the contracting party to the various New York Convention and model law, particularly New York Convention, where you seek to enforce the arbitral award over 160 countries. The third point is easily covered, the arbitral rules. So what this essentially stipulates are matters which Abhinav touched on at the start. If you are intending to have ad hoc arbitration, then you will not need to stipulate the arbitral rules. If, however, you are intending to have institutional arbitration, then you will be specifying the ICC, the HKIAC, the SIAC, ICA, and any other rules. What is very important is before making such a specification, you must be familiar with the rules, because each set of rules, much as most of the key and core principles are similar, there are certain differences that still exist within each of those rules. And in the event, for instance, your client does not wish a particular procedure to apply, for instance, an emergency arbitrator procedure, then they must specifically contract out of that. I then move to the fourth point, number of arbitrators. Generally, there's a default provision if you actually stipulate the arbitral rules that would apply. But in a situation where there's no default procedure, then you would tend to stipulate whether there will be 1 or 3 arbitrators. That is the usual number, and you would choose an odd number because typically any sort of dissent, any final decision will be decided by the majority of the arbitrators. I then move to the fifth point, which is language. And language of the arbitration, in essence, refers to the language in which the arbitration will be conducted. So it will be the language in which the pleadings are drafted. It will be the language in which perhaps the evidentiary hearing will take place. And I think this is also a relevant consideration, because insofar as if the documents and the witnesses are all in a foreign language, perhaps Chinese, in some of those instances where you deal with Chinese entities and Chinese contracts, it may be the case that you may not wish to stipulate the language of the arbitration to be English, because that may then require the translation of all the documents to English, and you may then choose to stipulate Chinese. The last element in an arbitration agreement that I would like to cover is that of the governing law of an arbitration agreement. The reason why this is considered as an element in an arbitration agreement is because an arbitration agreement is deemed separable from the main contract in which the arbitration agreement can be found. And because of this doctrine of separability, it is found that an arbitration agreement would actually have its own governing law to determine is there a valid arbitration agreement and to determine various other aspects of the arbitration agreement. So in a situation where there is no stipulation as to what is the governing law of the arbitration agreement, there then may arise a dispute as to what exactly is this governing law. There are various jurisdictions which have taken various positions on this particular point, and I'm sure many of my co-speakers will be familiar with ANCA, the UK Supreme Court decision, and may speak more about it. But I will just speak about the position in Singapore as to what would be considered the governing law of an arbitration agreement and how should a court actually ascertain this. It is a 3-step process, the Sul-America approach. The first is the court will look at the arbitration agreement itself, which means the arbitration clause, and see is there an express choice of law. If there's no express choice of law, the court would then consider what is an implied choice of law, and that's the second step. And the presumption is that the law of the substantive contract, if there is indeed one, would be the presumed or implied choice of law for the governing law of the arbitration agreement. And if there's still no answer after the second step, one then turns to the third step, where they actually look at what is the most closely connected jurisdiction to the arbitration agreement. So to a certain extent, while the law of the seat may be a relevant consideration, at least in the context of Singapore, when it comes to the second step, there's generally a presumption that the court will go with the law of the contract. But of course, this is always open to arguments. With that, that concludes my very brief run-through of the 6 elements in an arbitration agreement. May I turn the time over to Jo, please?
Thank you, Swee Ann. So the starting point, of course, if you don't have a draft arbitration clause in front of you or a precedent, is the model clauses that many of the institutions have put forward. So if I just briefly refer to Abhinav, if you could tell us about the ICC Model Clause.
Thanks, Jo. Most model clauses for institutions are actually freely available on the website. So whether it's us or SEAC or the others. And an ICC model clause, as you can see on the screen, reads, all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrators appointed in accordance with the said rules. Now, this model clause takes into account 2 of the 6 elements that Swee spoke about in the previous slide. What you need to do in this clause is you need to add in the other 4 elements, which is the seats, the number of arbitrators, and perhaps the method of appointing those arbitrators, whether that's 1 or 3, and the governing law and the language. That is very important. What is also important is that most institutional clauses and most institutions, in addition to having a standard arbitration, also have other kinds of arbitration. And those 2, without going into much details, are the expedited arbitrations and the emergency arbitrations. Now, unless you specifically carve out an expedited arbitration or an emergency arbitration, they would automatically be applicable if the conditions are met with. But if you do not want an arbitration if you do not want an expedited or an emergency arbitration, then it would also be advisable that you write in your arbitration agreement that the expedited procedures would not be applicable, or the emergency arbitration procedure will not be applicable. Now, of course, there are within the institutional rules certain sets of conditions that must be met for an arbitration to be expedited or for an arbitration to be an emergency arbitration, and that one needs to look at. Likewise, some arbitration institutions in their model clause also have the element of the law governing the arbitration agreement. And Swee spoke about the law governing the contract, and normally it is the seat that governs the law governing the arbitration agreement. But sometimes there's also a 7th element that institutions suggest, and I think we'll talk about it later. But that's pretty much about the ICC rules. The ICC, I think it is worth mentioning, have now come out with its new set of rules with effect from 1st of January 2021. So all arbitrations that are now filed at the ICC would be automatically governed by the 2021 rules. And there are many changes, but that's a subject matter for another conference. But with that, I'll give it back to Swee.
I think Abhinav spoke about the ICC Model Clause having 2 of the 6 elements. And I now want to show you the SIC Model Clause, which interestingly has 5 of the 6 elements. It says any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration administered by the SIC in accordance with the SIC rules for the time being in force, which rules are deemed to incorporated by reference in this clause. So you have the mandatory reference to arbitration, you have the institutional rules, you then have the seat of the arbitration, which is in the next line, you have the number of arbitrators, and you have the language of the arbitration. What is very interesting about this model clause is it does not actually provide for a governing law clause, which is actually found in the HKIAC model clause. I have to say personally, this has always been something which I feel, and if I'm advising my clients, I would advise them to simply put in what is the law governing the arbitration agreement, because that really obviates any needs and any uncertainty as to what is that applicable law, which we have seen played itself out in so many cases and has led to so much unnecessary litigation. Thank you.
There are also some other provisions that you might want to include in your arbitration agreement. One of those is the law or the governing law of the arbitration agreement or arbitration clause itself. I'll hand over to Daniel if you could talk about that clause a little bit further, and also some of the other elements that you might want to include and why you might want to include them in an arbitration agreement.
Thank you, Jo. So May and I are going to be sharing this slide, and I've got the 4 points that begin at the bottom, but with the law of the arbitration agreement that we've just been talking about. Before I say anything in detail about that, I think the headline point here is the one that Sui Yen mentioned and Abhinav alluded to, that because of the doctrinal notion that the law of the arbitration agreement can and sometimes will be a separate beast to the law of your main contract, this issue has assumed an outsized difficulty for parties in international arbitrations. Virtually no party really thinks about this issue, but it can, in rare cases, have important consequences. And what usually happens when controversy has arisen is that it makes a big difference whether the law follows the law of the substantive contract, what your governing law clause says, or the law of the seat of arbitration. And then there are arguments on both sides trying to explain which law, in the absence of choice, should govern. So the simple fix to avoid all of this is to make it clear in your governing law clause that you are choosing the law of the contract and also of the arbitration agreement. Very rarely do parties really intend the law of the arbitration agreement to be different from the law of the contract, although sometimes I suppose there would be good reasons to do it. If you don't express a view, you're probably going to be all right, because by and large, the way the cases have settled, and Sui mentioned the Inca case, which is like the Sul-America case, only with some refinements, but it did split 3-2, which shows even today how difficult the issue can be. You're probably going to be all right, because by and large that Sul-America approach has been preserved. The idea that the law ought to follow the law that you've chosen for your contract, but you can make it even stronger if you simply specify that point. So I think I risk confusing things more than is justified by saying more on that. So I'm going to stop there and leave anything else for questions. Turning to confidentiality, one of the advantages heralded about international arbitration is that, unlike international litigation, you ordinarily can be assured of some confidentiality protection. But it does pay to check the extent of it and where it comes from when you are making your choice about Sui Yen's second item, which is the seat of arbitration, because it's the seat that's going to give you the confidentiality protection. I mean, by all means, agree in your clause if you wish that the arbitration should be confidential, and or choose a set of arbitration rules to incorporate by reference that also say that the arbitration will be confidential, and that all is good sense, and many jurisdictions such as the UK say that there's an implied term of confidentiality even if you don't do that. But the more modern approach has been to put detailed legislation in place to say that if you're holding an arbitration in a particular seat, then a certain confidentiality code will apply to that arbitration. And that's certainly true now in Australia, in New Zealand, in Singapore, in Hong Kong. So those sorts of seats are relatively safe from that point of view, and the only difficulties around the edges are what happens if there's some sort of court recourse against the arbitration. How confidential is that? What if a judgment needs to be written? Will they redact the words, etc.? In terms of waiver of appeal on a point of law, I think the point here is that the model law does not include an appeal on a point of law as an available mode of recourse against an arbitral award. So if you're having your arbitration in a model law setting, you won't need this clause because you won't have an appeal on a point of law right in the first place. But if you put your arbitration in a non-model law or a modified model law jurisdiction, such as England, which is not a model law jurisdiction, or New Zealand, which is a modified one that has included for some arbitrations, although not by default international arbitrations, appeals on a point of law. If you want to get out of that, you actually have to look at the words of the statute and simply opt out at the beginning. And the lesson in all of these things and putting a clause together is it's a lot easier to agree these points of technical difficulty up front. Once a dispute's actually arisen, one side will usually have a vested interest in a technical point that would never have occurred to them as at all interesting previously, and so agreement can be harder to reach. And that aphorism holds true, I think, for the last bullet point, guidance on how to conduct the arbitration. It is something that you might think, because it's a lot easier to agree these things up front, you may as well just agree all of it in your arbitration clause and have a very long clause. And there's a certain amount of common sense to that, but unfortunately it doesn't really work, because you usually just don't know enough about what the procedure you're going to need for your dispute is going to be until the dispute's arisen. It might be a very big dispute, it might be a very small one. So if you think you do have that foresight and you've got the technical and commercial knowledge to negotiate these things and agree them, by all means go away and do it. There is some sense to it, but also be aware of hostages to fortune and not trying to predict and constrain an arbitral procedure when there isn't a dispute yet and you don't know what the dispute's going to look like. Thank you, Joe.
Thanks, Daniel. And some of the basic points you could include there on conducting the arbitration would be things like ensuring that the process is designed to encourage the parties to reach a cheap or cost and time efficient resolution of the dispute, and to not mimic court proceedings. And I've certainly seen that in some dispute resolution clauses. So for the rest of this slide, I'll hand over to May to talk about some of the other optional elements.
Thanks, Joe. Thanks to Daniel. So I'm going to speak first about interim measures, which is the second bullet point on that slide. It is an increasingly important topic in arbitration. If you can imagine that you sign an agreement where one of the disputes is that arises subsequently as someone's trying to breach a restrictive covenant, or you're trying to chase down some money and you need to freeze a bank account ASAP. This is where I think you can't rely on the result of the arbitration, which could come only a year or two later, but rather you need to seek interim relief as soon as proceedings start, or even before proceedings start. Now, is this provided for in the arbitration agreement, or can you rely on some of the provisions in the governing law or in the model law or in the arbitration rules? The answer is that in the old days, we do oftentimes see that provision for where you go for interim relief is provided in the arbitration clause. However, more recently, I think it's so well covered by the other areas, the model law and the arbitration rules, that people have stopped doing that, putting specific provisions in the arbitration agreement. As Daniel mentioned, sometimes it's less is more. And the way we now resort to interim relief is to basically rely on the courts of the seat of arbitration. Many institutions now have emergency arbitrator provisions, and interim relief is also available from the tribunal once it is constituted. So no special drafting is needed. But what you will need, though, if you think interim relief is something you are likely to need, or you're about to launch an application, is you do need specific advice as to whether your clause and your circumstances mean that all of those options are available to you, or whether there are only specific options that are available to you or specific options that are more appropriate. So you need to consider circumstances such as whether you are applying on an urgent basis, whether you need to apply on an ex parte basis, whether you need compliance to the order by a third party, such as banks, who's unrelated to the arbitration. So all of this you need to check on. And finally, you also need to check on the laws, of course, in the seat of arbitration. Just to use an example that's close to home for me, in China, as I alluded to earlier, there are only certain types of arbitrations which will allow you to access the local courts to obtain interim relief. So mainland China seated arbitrations, and recently this has been extended also to Hong Kong. So if you are very likely to need interim relief from a mainland China court, you might consider then to seat your arbitrations either in the mainland or in Hong Kong. So that's a very quick canter through interim relief. The next point is thankfully much more straightforward one. Awards are final and binding. And this is pretty straightforward because I think most students of arbitration are told that one of the benefits of arbitration versus litigation is that there are no automatic rights to appeal, either on errors of fact or, in most cases, errors of law. Arbitration is a sort of one-step process. There is, of course, a right to seek to resist enforcement for the party that's not happy with the award, or to try and set aside the award in the seat of arbitration. But these are on much more limited grounds, quite extreme grounds, such as, lack of due process if the party wasn't informed about the arbitration, for example, or access of jurisdiction by the tribunal, or certain very limited public policy grounds. So it's a much more straightforward and ostensibly quicker process than some litigation where a party has to wait for several rounds of appeal before they get a final decision on their dispute. Finally, the last point I will cover is on joinder and consolidation. This is another more technical topic in arbitration. Joinder refers to trying to bring a new party into an existing arbitration. And consolidation refers to trying to combine two separate arbitration proceedings into one arbitration. Why would you do this? The reason is usually because it is more efficient and cost effective, especially if the two proceedings or the party that you are seeking to join is related in a very detailed way to the existing dispute. So, for example, if you have back-to-back contracts, you see that a lot in sale and purchase. You're buying the same thing, seller sells to buyer, who sells to another buyer, and so on. And so it's the same dispute has impacted all of these series of back-to-back contracts. You may consider that it is more efficient in those circumstances to join all those potentially separate arbitrations into one. Construction contracts are another area where having joinder and consolidation rights is extremely helpful. And again, in the old days, I remember having to draft quite detailed and complex joinder and consolidation provisions to bolster the otherwise more straightforward arbitration agreement. And there was always a concern when doing that, these provisions may not necessarily work, because in the jurisdictions that we deal with, there's a high level of scrutiny in relation to making sure that the parties that we're seeking to join and consolidate have actually consented to these arrangements, and that might not be the case. Nowadays, thankfully, each institution has come up with quite detailed rules around how joinder and consolidation will work and when it's permissible and under what specific circumstances. So if this is something that will affect the contract that you are advising on, I strongly recommend that you check these details. And a lot of institutions have, besides the rules, they will have case study documents and other elaborations on the types of cases that are considered suitable for joinder and consolidation. Some institutions are quite conservative and apply quite a restrictive rule whereby all of the parties need to be party to the same contract and the same arbitration agreement, for example, and whereas other institutions are a bit more relaxed and they do not have that requirement. They just require that the dispute that is overriding all the parties or all the separate disputes is very similar, and the main terms of the arbitration are very consistent. And what I mean by that, it's factors such as seat of arbitration and language. If they are roughly consistent across the different contracts, they would then still consider joining parties or consolidating different arbitrations into one. So please do check this. Please also check where you are likely to have to enforce the ultimate award, because the enforcing courts will play a level of scrutiny on this, and they have to be comfortable that the parties they are seeking to enforce against have consented to the arrangements on joinder and consolidation. I'll hand back to Jo.
Thanks, May. That brings us to the last part of our discussion. You'd think that now, having seen the elements, the key elements that you would include in an arbitration clause, and having considered all the optional elements, that it would be quite easy to draft a clause. But as we're going to show you through some of these examples, it's not always so easy. So through the first section of tips, we will show you some of the clauses that have gone wrong, and just to indicate that clauses are not boilerplate. So I'll pass over to Swee Yan.
I was thinking, I think this might be Abhinav's clauses. Yes.
Okay, let me just... do you want to start, Abhinav, and I'll just pick up your other clauses for you?
Sure. So, at the institution, you pretty much get to see a variety of clauses. Some are very good, and some are not good at all. The worst thing that you can do to your arbitration agreement is to draft an incorrect or an arbitration agreement that doesn't really work. And what you see on the screen is an arbitration agreement which says, clause says, in the event of a dispute, the management teams of each party, to resolve the dispute amicably. If amicable resolution is not possible, the CEO of the party shall meet and attempt to resolve the dispute. In the event negotiations between the CEOs fail to resolve the dispute within 60 days, the parties will submit the dispute for final process to arbitration before the arbitration institution in Hong Kong. There is no arbitration institution in Hong Kong. What you might want to suggest, or what you would have written, was the Hong Kong International Arbitration Center under the rules of the Arbitration Center, under the rules of the HKIC. The arbitration will be before a panel of 3 arbitrators, with 1 arbitrator selected by each party and the chair selected by the parties. Jo, can we have the next slide, please? Yes. The other thing that what you don't want is that you want to keep the terms mentioned within the arbitration agreement as accurate as possible. In a clause like each arbitrator shall have the technical expertise necessary to evaluate the dispute, the languages of the arbitration shall be arbitration English and Chinese. We've seen arbitration agreements which have multiple languages because maybe one party is English and the other party is Chinese. That, of course, has its own effect on the arbitration, which is towards the cost, because then you have to translate every document in 2 languages, and that obviously increases costs significantly. I would allude to the fact once more and reiterate it, what Daniel and May also said, that less is more in an arbitration agreement. What you don't want is, I have seen pages after pages worth of arbitration clauses, and you don't want that. Most institutional rules actually already cover the basic structure of what parties like to put in an arbitration agreement. As long as you have put in your 6-7 elements, you're good to go. Do not try and make an arbitration very lengthy. I'll give you an example. I recently read a clause which said that the arbitration shall be decided by a sole arbitrator, full stop. And then it said he should reside in Russia, should have 10 years of maritime law experience, and should have some sort of a business in London. Now, we kept looking for a maritime lawyer in Russia, and the one that we found was a she, not a he. But the arbitration agreement was gender specific, and we couldn't appoint that person. It was just a pathological clause that we couldn't do anything with. And therefore, try to keep your arbitration agreements gender neutral. We don't know. Do not try and keep names, specific names. Today, you're drafting a contract and you want, say, Abhinav Bhushan to be your arbitrator. But Abhinav Bhushan may not be around for another 20, 30, 40 years when the dispute actually comes to surface. So you don't want to put specific names within the arbitration agreements. You want to avoid these rookie mistakes. I'll give it back to Joe for, there are other tips and drafts. I can cover more, Joe, if you like. But if Daniel is left, is it? Okay, Daniel has had to leave. Okay.
Yes, we'll come on to the other ones in a moment. We're just going to pull up the other examples that we have, which I can do if I stop sharing. I can just quickly pull those up. Okay, let's try.
Yes, otherwise I can share it from my end, but
okay, that'd be great, Sriyan.
Yep. I have to I think you have to stop. Okay, yeah.
Yeah, I've stopped.
Thank you. Okay. Can you see the slides?
Yep, we can.
Yes. Okay, let me go to the slides in questions. Is it on the full screen? Is that
yes. No, just put it on slideshow.
Okay.
Down on the right-hand corner.
Thank you. I'm just not that apt at sharing slides. Sorry.
Likewise with me.
Good time to take a break. Do you see the full screen?
Yes.
Yes. Does it work now? Yes. Do you have it?
Mm-hmm.
Great. So what I wanted to add on from what Abhinav just said is that really, when you have these various model clauses that are already available in the institutional rules and readily available on their website, it is really quite wise to use the model clauses, otherwise beware. I wanted to run through some examples to show you that there are indeed all these clauses and effective pathological clauses which have been through the courts in various jurisdictions. The first example is where there's a reference to both litigation and arbitration. In the event of a dispute or difference arising out of or in connection with this contract, the parties hereby agree that such dispute or difference may, through election by other party, be litigated or referred to arbitration in Moscow. This creates a problem because a party can simply get out of the arbitration agreement or escape from that obligation by electing not to go for arbitration. So we have stated it would be good to put a mandatory reference to arbitration using the phrase shall be resolved by arbitration. Example number 2 is one where you actually see the problem with the clause is that there are actually 2 seats of the arbitration. If you look at the third line, it says any dispute shall be referred to and finally resolved by arbitration in Singapore, India, administered by the Singapore International Arbitration Centre in accordance with the arbitration rules of the Malaysian Chamber of Arbitration. Not only is there an issue with the 2 seats, there is also an issue with the fact that there is actually a non-existent arbitral institution called the Malaysian Chamber of Arbitration. If you have a non-existent arbitral institution, that is what sometimes parties would term as causing a pathological clause. So the right institution should be the Asian International Arbitration Center. Other examples, example 3, if the scope of your arbitration clause is too narrow. So for instance, if you only refer to the commercial dispute or difference arising out of this contract, there would be an argument that may be made that this is not wide enough to cover all types of disputes. What is considered a commercial dispute? One can imagine that there will be many arguments made about this. Would this cover a tortious claim? Would this cover a statutory claim? And again, that will affect and cause unnecessary litigation and legal proceedings over the scope of this clause. The next example, number 4, is another example of a non-existent arbitral institution, where reference is made to the Singapore International Chamber of Commerce in Singapore. So what does this actually refer to? Does it refer to the International Chamber of Commerce, ICC, which is based in Singapore? Does it refer to the Singapore International Arbitration Center, which is the SIAC? Or could it even refer to the Singapore International Commercial Court, which probably is the least likely? But again, it is very important to ensure that the right institution is referred to. Other examples, in the first example, number 5, where there's a reference to say that agree that all disputes that cannot be settled by discussion and mutual agreement shall be referred to and finally resolved by arbitration as per Singapore contract rules. Again, there are no such rules. And there was then a dispute between the parties which went to the Singapore courts as to whether this is even a valid arbitration agreement. I would like to inform you that the courts, having gone through this clause, found that what they could see from this clause is that there was clearly an intention to arbitrate. So they upheld the arbitration agreement, but said that this in essence was an ad hoc arbitration. The next example 6 is actually a very famous example, which also found its way to the Singapore courts in the Insigma case. And this is where there was reference to arbitration before the SIAC, but in accordance with the ICC rules. There becomes an issue because generally the ICC rules cannot be administered by another non-ICC institution. So this again caused issues, and the parties were in a fix as to whether and which institution was prepared to administer the arbitration. What the court actually decided was that, again, there's a clear intention to arbitrate, and if SIAC was prepared to administer it, they are prepared to let the arbitration proceed. One last example that I will end with, because this is a most recent case of 2019 before the Court of Appeal, which also dealt with the earlier point I mentioned as to the 3-step approach that the Singapore courts take to determining the law of the arbitration agreement. The problem with this particular clause is that the clause says that such dispute shall be finally submitted to the SIAC for arbitration in Shanghai, which will be conducted in accordance with its arbitration rules. The problem with this is that the reference to arbitration in Shanghai, it is not clear as to what exactly is meant by the reference to arbitration in Shanghai. Should it be read as a choice of Shanghai PRC as the seat of the arbitration, or is it simply referring to Shanghai as a hearing venue of the arbitration? Ultimately, the Singapore Court of Appeal said the natural reading of this must mean that the parties choose for the seat of the arbitration to be China. Thank you, Joe.
Thank you. So just on a few more tips and traps, I'll ask May to address the next two, tips number 2 and 3.
I will stop sharing my slides, or should I can continue sharing the slides and help May with it. Should I do that?
Sure. Okay.
Okay. May?
Thanks, Joe. Thanks, Suyen. So actually, this next tip is something that quite a few of the speakers touched on already. You need to consider the scope of the clause, and in particular, make sure that it is very broad so that it covers all disputes. Otherwise, you might end up in no man's land in relation to some disputes. So, for example, in the example that Suyen shared earlier, where only commercial disputes are subject to arbitration, what happens if there is another dispute that is not deemed to be commercial? Then you might end up in a situation of not knowing where your dispute can be resolved, and then having a prolonged and expensive dispute over exactly where that dispute should be heard, even before you get down to dealing with that dispute itself. Are the steps mandatory or permissible is, again, very important. The obligation to arbitrate has to be mandatory, but occasionally you may consider bolt-on pre-arbitration steps, such as, mediation or negotiation at the senior executive level. Make clear whether this is permissible or mandatory. You might even go so far as to put a time frame around it, such that if the discussions fail within 15 days or 30 days, parties know when they need to move on to the next step, which is usually arbitration. And is a step dependent on a later agreement? So this refers to whether there is something that specifically will trigger the arbitration. So one type of trigger is, for example, the prior step of going to mediation or having a senior exec negotiation. I would not otherwise suggest having too many triggers or requiring a specific later agreement between the parties, because, as you can imagine, if you're the claimant and the other side's the respondent, you're not going to get the respondent necessarily to agree to arbitrate disputes once the dispute has arisen. One type of later step could be formal written notification within a certain time frame. That is quite commonly seen. And again, if the scope of the obligation is drafted clearly, then there's no reason not to put it in. But if you cannot articulate exactly what needs to be done before you trigger the arbitration, then our suggestion is always less is more. Thanks, Sui. I can go on to the next slide. The next tip is carve-outs from the clause. And again, the theme is, if you want to have a carve-out of certain disputes from the scope of the arbitration agreement, you need to be very clear and specific about what you are carving out. Otherwise, again, you might end up in a big jurisdiction battle even before you can get your underlying dispute resolved. That the battle will be between, who has jurisdiction over the dispute in question. Does it fall within the carve-out or does it not? And who gets to decide whether the dispute is arbitrable is also a big question. It may be decided by the courts. It may be decided by the tribunal. You may end up having this dispute in both forum, because one party has decided that the dispute properly falls within the jurisdiction of the court. The other decides the reverse, that it should be the tribunal. And all this takes time and a lot of money. Now, it is sometimes appropriate to have carve-outs, and I think the slide alludes to some of this. So, for example, if you have an M&A, and completion accounts is usually a big feature of an M&A deal, and it's considered appropriate that an accountant should deal with any disputes relating to the completion accounts, then by all means have a very specific and narrow carve-out for that to go to expert determination by an accountant. Other areas where may be appropriate to have a carve-out that I've seen in the past is where you think there might be a dispute in relation to competition law issues. Insolvency might come into question. Certain IP issues might come into question, which is or have been advised is not appropriate for arbitral tribunal to decide, or it's not arbitrable under the national law. then it may be appropriate to have a carve out for those disputes to go to litigation and everything else to go to arbitration. Thanks, Sui.
Thanks, May. We only have a minute and a half left before we're going to be thrown back to the plenary session. I'm not sure if we'll have some time to continue with questions there, but just in the last minute or so, if you could mention the last two tips, Arbi.
Sure. Very quickly, keep the clause simple. Be aware of the possible disadvantages of multi-tier clauses, because you need to be sure about what kind of multi-tier clause. Are you first going through negotiations, then you're going through mediations, and then failing which you're coming back to arbitration, and then perhaps during an arbitration you're resorting back to mediation. You have to be extremely cautious as to not to sort of overfill your arbitration agreement with multi-tier clauses if that's not necessary. We've already spoken at length about the optional clause, and also look at the additional elements. An arbitration agreement is like a buffet. You can add on whatever it is that you like, but you got to be careful whether you need all that you want on that plate. You need to be able to eat and have an appetite of what's in your arbitration agreement. So, for instance, you don't need, for instance, if there is something that reads an amiable compositeur, where an arbitral tribunal can decide a matter based on fairness and equity and without really following the general laws and regulations. Do you really want that? So make sure that there are no additional elements. And I'll quickly move on to the last slide, which is check your cross-referencing. It is absolutely critical that, especially in a multi-party, multi-contract scenario, that your one contract number 1 and your contract number 2 or 3 or 4 are consistent with each other. One contract should not read your seat in New Zealand, in Wellington, and the other one reads in Sydney, and the third one reads in India. They should all be absolutely consistent. Cross-check references, especially with the dispute resolution clause. Check timeframes between different mechanisms. Make sure they are absolutely accurate and they are tight, and there are no loose ends with the times frames between a mediation and a negotiation and an arbitration. And last and certainly not the least, make sure that your clause is certain and enforceable. And when I mean enforceable, there are certain subject matters which are not arbitrable in the first place. For instance, there are many jurisdictions where intellectual property matters are not enforceable. There are many jurisdictions where domestic cases are not enforceable, are not arbitrable. Therefore, you do not want to have arbitration where the law of the land does not permit you to do arbitration in the first place. So check those key elements with the lawyers, or read up what's necessary to draft that arbitration agreement. I am very conscious of this sticker that's on the screen. It's 50 seconds now, but thank you so much. That was that's all I had to say before that. Thanks.
Thank you, Abhinav, for that very brief session on the last couple of tips. And thank you also to May and Sui Yan and also to Daniel, who has unfortunately had to drop off the call. If we do get to go back into our breakout rooms, then we can address any questions that you might have. Otherwise, I understand we're now going to be thrown back to a plenary, and then there will be the last session of the afternoon, which will be done with Daniel and Christina. So if you are unable to ask questions, and you do have some, please reach out to any of us on the panel, and we'll do our best to help you. We can give you our contact details, or Christina and Daniel can assist you with that. So thank you very much. I hope it was interesting and comprehensive.